Good afternoon. It is, in fact, afternoon. So that is a true statement. My name is Arwen, and thank you so much for being here. I appreciate it today. Welcome to today's presentation, Navigating New Federal Regulatory Challenges. I am your host, Arwen Robinson, Director of Marketing with Advanced Benefits, alongside my colleague, Stephen Sully, CEO of Province Management Groups. And today we're very excited to take you through this presentation. As you have questions during the presentation, please utilize the chat function. We will have a Q&A period at the end of the webinar where we will address any questions that were not answered during the course of the presentation. You may have noticed that this presentation is being recorded. If you do not wish to participate in a recorded call, please disconnect yourself at this time. Additionally, this webinar is qualified for a SHRM CE credit for participants who attend for the full presentation. Your CE credit will be emailed to you by Advanced Benefits within 3 to 5 business days after the webinar and your full attendance is verified. This presentation is a courtesy service to our clients and friends. It is designed only to give general information on the developments actually covered. It is not intended to be a comprehensive summary of recent developments in the law, treat exhaustively the subjects provided, provide legal advice, or render a legal opinion. Advanced Benefits and Province Management Group and its employees are not attorneys and are not responsible for any legal advice. To fully understand how this or any legal or compliance information affects your unique situation, you should check with a qualified attorney. Now, I would like to introduce our presenter today, Stephen Sully. He is an entrepreneur who has spent more than 25 years founding and growing companies in the insurance industry, healthcare technology, HR administration, and recruiting and staffing services. He is currently the CEO of multiple companies based in Idaho, including Province Management Group, Ataraxis PEO, Beneficient, and Talent Fill. Stephen's personal mission is to maximize human potential and help both businesses and nonprofit organizations be the best that they can be. He was the founding president of the Idaho chapter of the Entrepreneurs Organization and is actively involved with multiple leadership groups, such as Boise Vistage. He was recognized as one of Idaho's Business Review's CEOs of Influence in 2020. He has volunteered with several nonprofit organizations and served on multiple boards, including Make-A-Wish Idaho, Light My Fire Inc., and the Scott Esplin Memorial Foundation. Stephen and his wife, Jessie, live with their 4 kids in Boise. So that is quite the introduction, Stephen.
That is quite the introduction. Thank you.
Of course. So I'm going to go ahead and stop sharing my screen. Oh, I did stop sharing my screen. Perfect. You should be able to share and take it away.
Well, I probably should be better prepared to have the slides up on my computer.
You know what? It's just a Thursday. It's all good.
That
No,
is
I'm
right.
very excited about this presentation, especially because I keep seeing more and more developments in the news. And there's a little bit of like, well, everyone in the news has an agenda. And so I'm excited to hear, like, let's cut to the chase. Let's get rid of all the fluff. Let's figure out what's actually happening here.
Yeah, it's definitely a whole new world when it comes to this stuff, and they're making changes every day to things that the people use and businesses use. And if you're not prepared, it's really going to be something that unfortunately could to trap you where you don't really want to be trapped, because it's never a good thing. So can everybody see that okay? Can you
That
see
looks
that,
great.
Arlen? All right, perfect. Let me get this over here. So again, I want to thank you for the introduction and everybody taking the time today to go through this. As you said, I don't know if there's an expert anywhere in all this stuff, whether they're attorneys or congressmen or anybody else. So it's definitely something that is changing all the time. And so we'll kind of hit that. So there's a lot of new rules actually that came out over the last couple of weeks, really, that are going to affect things and change very much across the company or the country, excuse me. The first one being the Department of Labor and their minimum salary levels and their overtime pay. Classification of 1099s, which is a very big one that we have to watch, because it's as we'll get to, it's something that can be highly complicated, and also everybody has an opinion depending on what they want their outcome to be. So we have that, and then highly compensated employees and how those will be affected as well. And then we'll also talk about the non-compete ban that I'm sure everybody's already heard about, but we'll get into it a little bit more. So we'll start with the minimum salary levels and overtime. These are interesting, and I wanted to bring up all three so we could see how they're going to affect it, because it's only going to take 8 months before we end up at the highest level. And if anybody was paying attention, it was about 9 years ago in the Obama administration, this dollar amount coming in January, the 58,656, was what Obama was trying to get in place back then. And they finally actually got it through now. And this is the DOL with the salary. Salary requirements. A lot of people don't realize still that there is a minimum salary requirement for someone who is on salary. And so currently it's 684 a week or 35,568 a year. July 1st, it's going to go to 884 a week, 43,888. And then there's also a little bit more rules involved with how you're going to be able to determine whether someone is salary exempt. And there's more detailed information that we can send out afterwards, Arwen, if anybody would request it about some of those different things. But really, it's going to come down a lot to management level decisions. Do they manage people, and do they have a financial impact on the organization? So just because someone works a lot of hours doesn't mean you can just put them on salary. You've got to be very careful about that. But where this is really going to affect things, and where I believe that the DOL is incorrect in the 4.3 million workers that will be impacted, is what they're really not taking into consideration, and what you really need to stop and evaluate as you are working with your employees on whether or not they meet this criteria, and how you plan to take someone $23,000 a year more than they currently make. So $2,000 more a month. Well, that doesn't impact just the people that are below that 58,000, because you shouldn't just plan to make the 43. You really just go ahead and decide how are you going to deal with the things that change in January. But the problem, and the biggest problem here, are what are the people, let's say they make $60,000 a year now, and you've got people at the level current exemption of 36,000. How do you take someone from 36 up to 58, almost 59,000, and not affect all your people above that are already above it? So now all of a sudden you take a delta of 24,000 and you squeeze it to 1,000. It's really going to cause a problem. And if the HR professionals and the managers and the business owners are not taking this into consideration, there is a massive impact of sliding scale of salaries that are going to come in here, which I believe is far more than 4.3 million people in the United States. So that is something that is going to, I believe, almost harder to figure out what to do with that if you just move your salary level to what will be January 2025. I think you also need to make sure that you're really evaluating whether those positions qualify for salary exempt. And then you also need to look at, if you're going to convert somebody from salary, how do you deal with that? What do you do? Because if you take them to hourly and they're used to working in the evening and they have a phone that they've got their email on and they're doing all these things, they can't do that anymore legally without getting paid overtime. So this is far more drastic impact to businesses than I think people are really giving it credit for, or the DLL is actually looking at the impact, because this is going to affect everybody, because it can change very, very drastic changes to the businesses and impact a lot of people in your organization. So this is one that you really need to be looking at now and planning for. There are also not very many, but there's a few states that may have some higher salary thresholds than the federal minimum wage. I personally haven't seen what they're going to do, if they're going to change those, or if they're going to increase them the way that they are, with this. A lot of states that have hourly minimum wages that are higher than federal will adjust those if the feds ever adjust minimum wage. So they might be doing that. So you're going to want to look at the states that you're in and make sure that there isn't some other impact besides just the federal minimum wage on that. The next one that is quite a change, very big change, that people are trying to figure out still is the 1099 rule that the DOL put in place, um, that will go into effect. I believe it's July 1st on this one. And they changed it. There was a 5-factor ruling before, and decision process that had 5 different factors in it that you could really kind of see which one or two that they fit in. And it was almost more of it. There was a majority of those that they fell into. They were really a 1099 versus a W-2 employee. And I will tell everybody right now that you should make sure you're very, very careful with your language, because there is no such thing as a 1099 employee. They don't exist. They're like leprechauns. Everybody wishes they were real, but they are not. Because a 1099 employee, that is a contrary term. 1099 means they're independent of your business and they work certain aspects with you and do certain things with you. Employees are yours all the time at your full direction. So watch your terminology. Watch your terminology. I've seen it on paperwork. I've seen it on websites. I've seen different things with that language of 1099 employee, and you should make sure you don't have any of that there, because if you get into some kind of battle with somebody, whether it be an individual or some kind of department or the DOL, they're going to look at all those things and how you treat them, as to whether or not they determine whether you are treating them like an employee or not. The other thing that you'll get caught on when you're in a contractor battle is also if you pay your 1099 contractors on the same schedule as your payroll. This is the worst thing you could do. So make sure that you're actually treating them like a vendor and paying them at a different time period, and have different processes for getting their time if you pay them on an hourly basis. Make sure you have different processes for those things so you can show a true delineation between a 1099 worker and a W-2. So we'll get into these totality of circumstances approach is what they're saying. And so they are looking at all of these factors. They say they don't weigh one more than the other, but I would say that they're still probably going to end up in there. This approach has also become very friendly to the contractor, especially if they're trying to be an employee, which so many of them actually are trying to be. And that's really the issue with this. So the first one is that do they have an opportunity for profit or loss? And that means, do they run their own schedule, their own P&L? Can they actually decide when they make money and when they don't work for you and don't do something? A great example of this one that they are saying that it fell into is the rideshare apps and some of those delivery apps, where they can choose to do it or choose not to do it, and how that comes about and when they do it. So the resource is basically they have an app where they can sign in to do it, but they're not telling them anything more than that. And that's really where a lot falls in there. The investment of the parties is another one. Do they invest in their own business like a business owner would? Or they have things that they have to buy that's for them that they could use for anybody, not just you? The permanency of the relationship. If it is a long-term thing where someone is doing some type of work for you and they're doing it, let's say 30, 40 hours, even 20 hours a week, and they're working on it with you, and they've been doing it for years and years, and they don't do it for anybody else, you're going to have a hard time now winning that challenge as to whether or not they're a part-time employee, because they're only doing it for you. The control over the work. If you tell them how to do it and it's not more than a normal vendor outcome of, I need you to do this deliverable and I need it by this date, that's great. You can't control when they do it during the day. You can't control how they do it or anything else. They have to have more of a deliverable or an outcome like that. Is it truly integral to your business? This is more of a new one. If you rely on them heavily for how your business runs, you're going to have a hard time saying that they're not someone that should be a W-2 employee. The skill and initiative. I've seen so many of times where someone is put in as a contractor, but they actually have no skill and they need to be trained into the position. That is going to be seen as an employee now too, especially when they really have a hard time going through it. Unless they are truly a startup business and they're trying to do it, they've invested in their company, they have a company, they're doing it for other people. That is where you're really going to want to pay attention to those things and how you're treating somebody that way. Be careful with all those things. This, of course, is going to be challenged in court again. There's so many people that have some stake in this game. A lot of people have businesses that revolve completely around contractors and contractor relationships, and it's something that you really have to evaluate for yourself. Um, do not. I've heard so many times where somebody says, "Well, I have a letter from an attorney that says I'm good with contractors," and that could be 10 years old. If it's 10 days old, you might have a problem right now with the way things are changing. Be very, very careful with what you rely on, because that attorney is not going to indemnify you against anything when it comes right down to it. So be careful of how you evaluate this and what you do, and really look at it for your business. And don't rely on on anybody else's business that may be similar to your industry, because they might have a completely different business model, even though they have the same product. So be very careful about what you rely on and evaluate it specifically for you. And I would err on the side of caution. So the DOL made this ruling, and it is a DOL ruling. There are also IRS rules around contractors and how they're treated and how you pay for them. The FLSA also has a few rules around contractors. They're not changing theirs, and they're actually starting to refer over to letting the DOL make the decision. So really be careful around that. If the IRS, for instance, deems that you have misclassified an employee, which is what they're all now calling it, is misclassification. If you've misclassified an employee, the penalty is rather stiff from the IRS. They'll go back as far as long as they will determine that they were acting as an employee. And from that point forward, contractors, as most people probably know, big part of it is the employer doesn't have the FICA tax, and the contractor has to pay that themselves, 15.3%. If the contractor, let's say they paid all their taxes, but the IRS comes back and says, hey, these people were misclassified, the penalty for that employer is the full FICA tax, the 15.3%, plus the penalties and interest for not paying. It's the failure to pay penalty, which is 20%, and interest from that point in time to going forward. It can get very, very expensive. So it's something to look at. And current administration, and we all know, who knows what's going to happen. These are the rules as they stand now, and you have to make sure that you're paying attention to those and making those decisions for your business.
Stephen, when you're talking, it sounds like, you're talking about these penalties and these fines and everything. And all I see is like a little cartoon IRS character with dollar signs in their eyeballs is kind of the image that comes to mind for sure.
Well, absolutely. And I think, if you've been watching the news, you see that the IRS is making moves now more and more to, audit more businesses and, find more people who are not paying the taxes the way they believe they should be paid. They don't care what you believe, it's what they believe.
Yeah.
And at this point, you have to be very careful around that and make those decisions, because they want more money, and they've been, given the job of collecting it. So really be paying attention to what could cause you problems.
And one thing you said earlier that I think was kind of a light bulb moment for me is when you're saying that there's this misnomer of calling them 1099 employees, and when you're like, nope, get that out of your vocabulary, right? They're 1099, and when you think of them in terms of contractors, right? 1099 contractors, and if you ask yourself, well, if this was a contractor, would I treat them this way? And like your point about pay them on a different schedule, right? Do they have their own P&L, right? There's a lot. I think there's probably a lot of people out there that are, that aren't operating that way, that should probably be an employee. So I think like that was kind of the light bulb moment for me of like, this is how I need to look at it.
Yeah. I mean, with one of the things that we run into, we work in a lot of different businesses and a lot of different capacities. And some of them in this regard is workers' compensation. What is your obligation to workers' compensation for a contractor? Well, by law, it says that if you have a contractor doing work for your business, they're supposed to supply you with a certificate of insurance saying that they have coverage for workers' compensation, whether they're a single person or they run a team. They have to supply that to you. Your insurance company, by policy and law, says that they have the right to ask if they have coverage for those. And if they don't have coverage, and you can't show proof, they have the right to charge you the premium for them. Because there is exposure there. So it's another thing that you really have to look at as you're going through contractors. It's not an easy, I'm going to pay you a couple $1,000 a month and do this, and we go on our merry way. It's something that everybody really needs to pay attention to.
And then we have one question that I think is one question
Sure.
I had as well, is that when it comes to these new final rules, is it you don't pass one of these and you're done, or do you pass the majority of these, right? Do they have, when we're looking at it, these contractors, do I have to be able to pass all 6 of them? What does that look like from like a test perspective?
Yeah, that's why they actually did change the title to the totality of the circumstances. What I've been reading and the opinions of a lot of people, the attorneys and a lot of HR people who deal with a lot of this is it's kind of really going to fall towards more of a majority. Like, what is the majority of it? And they're still seeing that, the profit and loss one has come up more and more. Like, do they actually have the ability to control how much money they make whenever they want to make it? If you have a requirement that you do so many things for you and they have to do it, you're going to run into that control over work and the opportunity for profit and loss, and then also their decision as to when they want to work. So you really have to look at all of them and kind of make a decision around on each one of these. Am I falling into this more than not? If that's the case, you probably are running into a situation where they're more of an employee than they are a contractor. But it's no longer you can hang your hat on one or two saying they are definitely not this, so they're not. And that's why they did change the rule. And they even, they made the 6 factors, but making it a totality of, they really want them to have their own business. Like, one of the things that I read in the opinion when they wrote it was the decision around the workers' opportunity for profit and loss. Part of the test was, are they actually running a business? Are there, you can file as a sole proprietor on your 1040, but are they really running their own business? Do they have a business? Do they have business cards? Do they promote it to other people? What are they really doing? That's part of what they're looking at. Is if they're not acting like a business themselves, then are they really a vendor or are they really an employee? So they're starting to look at it more and more that they expect that these contractors are small business owners. Can I go to the next slide?
Yeah, let's go.
All right. So the highly compensated employees is really interesting in regards to that the minimum wage, the new minimum wage for salary, is they increase this as well. And this is where you get certain exemptions on how you treat a salary worker, what they can do. They apply in some regards to other benefit plans. They could be adopted. They're trying to streamline a lot of these things because there's highly compensated, Arwen, as you know, in benefits. For instance, ERISA has highly compensated rules and how you go about that. They're kind of really trying to align them where the DOL had some of their own rules for highly compensated. You'll see that these numbers that they're bringing in 24 and 25 are actually closer to the numbers that you see in the ERISA highly compensated. So they're trying to bring it all together because that's a huge jump as well. And so you just have to just kind of watch this. But I will say, you end up this doesn't affect outside salespeople and inside retail, which is really interesting. They've got exemptions for those things. And that is an interesting part of the highly compensated and how they're addressing that. And because some of the rules don't apply. When you get into highly compensated, they don't have to have effect on business, like the profit and loss of the business. They don't have to even manage people. They expect that if you're paying them this much money, they're being paid fair enough that it doesn't matter what their job responsibilities are. The DOL is not going to really worry about them. So all the other rules for underneath highly compensated don't really apply to them. The one other big change let me go back. The one other thing that they are finally doing in this that I think that the rules really, are in place for many different reasons, and that's probably a whole nother webinar and maybe even a cocktail party conversation. But these are going to now be updated every 3 years automatically. They have never put that in place before, and they are now going to do that. So as inflation goes, They are going to adjust this, and this also goes for the salary exempt levels. So these are going to move. So it's going to now it's not just a one-time, let's make a decision of what we're going to do happen in 2025. It now has to become part of your strategy and your employee strategy and your wage strategy and your profit and loss strategy for your business, because it's going to change. Every 3 years, you're going to see some change. Now, if you have a catastrophic event in the economy, it could go down. Let's hope it doesn't, but they are going to fluctuate. But that is something new that they've never put in before, and so you're going to want to watch that. This I was actually surprised by, and I still personally question the FTC's right to do it, but they are so overstretching on interstate commerce and interstate trade that they believe that there is no business anymore that doesn't qualify for this, because they're basically going to the level of, if you buy from Amazon, you're probably doing interstate commerce. If you buy online, you're doing interstate commerce because you're interacting with other businesses, not just in your area. So you could probably argue this if you truly, only did cash and didn't weren't on the internet. Other than that, you're going to have a hard time arguing that you don't qualify and aren't required to be fall under this rule. But they killed all non-competes. Non-competes no longer exist as of what we expect to be September, which we'll come to. But they don't exist. They immediately, when the rule takes effect, non-competes are gone, and they are for all U.S. workers. Here's what's really funny is independent contractors can't have them either, which is really interesting, because that was one of the ways that they would catch people of misclassifying employees, was having a non-compete for an independent contractor. Because how can you have a non-compete for somebody who's supposed to work for lots of different businesses? That was a problem, but they killed them for that too. Limited exceptions, meaning that you can do it with trade secrets and some other things with contractors, but those existed before, and those are usually more of a contract situation and not really a non-compete. A non-compete, and the reason that they said that they needed to get rid of them was they were too restrictive to people making a living, and you can't do that. And that was why, for the last few years, we've actually recommended to our clients that you don't use a non-compete, because they don't hold up very often. Because it's very hard to prove that you're not restricting someone's ability to make money where they live. And that was a big part of it. So all of these, they're going away. And then of course, they created more work for us as employers, because you have to send everyone that you have, a current or former. Now, former goes back, I believe it's anything that's currently in effect. If it's not in effect, you don't have to send somebody a letter saying their non-compete is done. But if you have, if you just negotiated something with someone that left your organization, and you put a non-compete in place that said that they couldn't do X, Y, and Z, I would really hope in that non-compete, you also have some language around what we have been telling our clients to do for a long time, which is, using language around non-disclosure and confidentiality. Those are better to do anyway, because you can let them do business with anybody, but you restrict them from using anything they learned in your business or clients that they worked with in your business for a period of time. Those are still enforceable because you're not keeping them from working. So it's that. And so hopefully you have those in the non-compete agreements, because that can stand up. I'm sure all of this will be challenged. It's early September that we expect it to go into effect, because it was 120 days from the time it hits the Federal Register, which was last month. So this is a really interesting one, but they killed it. The only ones that can stay in effect now are someone that falls under a highly compensated, I believe it was, they defined it as around $150,000 a year, and an executive in an organization. And those can stay in effect until the person leaves the organization, which essentially kills them, but it keeps them from competing with you while they're working for you, which, I mean, it's all illogical, but that's the rules. And so that's what they're doing. So essentially they killed all the non-competes. But get with your employment attorneys, your HR, professionals, consultants, whoever you might work with. If you have questions for us, we'll be happy to work with you and talk with you about that. But really start looking at what are the alternatives. And I've always been a big fan, like I said, of the confidentiality and non-disclosure.
Yeah. So Stephen, let's talk a little bit about that. And so, for example, we have a lot of clients that are in manufacturing where they've found a particular way or they've really honed in on, a proprietary method. And so, if these non-competes go away, what I heard you describe is that the non-disclosure agreements are still enforceable, and that's
Mhm.
how you're able to protect essentially those trade secrets, if you will.
Right. I mean, the big part of this, when they came out with it, they said it is again restricting people from making a living. You can't restrict people from making a living where they live. Well, you can make sure that you can have an agreement that says, well, that's fine, but you can't use my trade secrets. And there's other anti-competition, or not anti-competition, but competition rules on the books and laws in a lot of states that keep people from using trade secrets. So there's things like that that will keep people from being able to take what you've developed and go use it themselves. A non-compete isn't necessarily going to do that. So, but if somebody wanted to leave your organization, set up a shop, they can't use, if you have a non-disclosure and a confidentiality, they can't use anything they learned in your organization. They can't use any information about the clients that you have because they can't disclose that they know that they were a client, and they have to keep it to themselves. So how do you call somebody and try to steal a client without disclosing that and you had them? And so that's where that will keep people from doing that kind of thing. And I think it's been seen to be more enforceable anyway than a non-compete. So there's good alternatives out there.
And then Stephen, I was kind of curious. I was like, well, where are we at on this? Because I know that it's expected to take effect September, but we also know that the U.S. Chamber of Commerce has been very vocal that they're gonna plant that flag on the lawsuit. But what I thought was really interesting is that just kind of looking at where was this at, that the federal judge in Texas actually had to tell the U.S. Chamber, hey, you guys actually didn't get to the ball first. Because there is a first to file doctrine. And so as of yesterday, as far as I can tell from I'm just looking at the filing now, that
Mhm.
an organization called Ryan LLC was actually first to the punch on the lawsuit against the ban of the non-competes. And so it looks like it's going to work its way through the district court. So I mean, but all that to say, I'm kind of looking at a crystal ball, if you will. Do you think that we're going to see a judge issue a stay on this taking effect until this lawsuit can work its way through the court systems?
Well, I don't know Ryan LLC and what they do. It's interesting that they want to be the one, and I'm sure there's lots of funding behind their lawsuit. But they're going to have to show some financial impact directly to them or prove that
Right, like
there's
prove
financial impact
damages, right?
in order to get some kind of injunction against the FTC and this rule going into effect. Lots of judges that'll give certain things, and obviously they're filing where they believe it's the most friendly to get an injunction.
Advantageous, if you will.
Yes, advantageous for sure. So, we'll see if they file an injunction. They can file an injunction, and then the FTC is going to come right in right away, take it to an appeals court and appeal for the injunction to be lifted. And then, this is going to go to the Supreme Court. It will, because there's no way it won't if there's enough lawsuits with it. And there may be even the opportunity for some of these people to come together in the lawsuit. So I expect the Supreme Court to end up weighing in on this one, and I think it's kind of up in the air as to whether or not that they would uphold it. There have been far too many court cases, and one of the reasons the FTC and what they cited in it is there's far too many court cases that overturn non-competes because there's so many egregious non-competes out there. And so it's really going to be interesting to see what the Supreme Court does, and it's always interesting to watch these things. Uh, if the injunction goes into place, I would expect that it's probably one that they would hear, and we'd have a decision next year. by the Supreme Court if it can go that fast to get there. And the FTC could also petition the court to take it up as well. Even from the court, if they say, look, let's just bypass all this. This is supposed to go into effect. And if the court decides they want to take it, they could. So we'll see. It's always, like I said, it's always entertaining.
Yeah, Stephen, I don't know about you, I'm starting to feel some deja vu with the COVID vaccine lawsuit that worked its way through the system where they were gonna require the vaccines to come back to work, and it's feeling a little deja vu-y right now with
Yeah.
that.
Yep. And there were a lot of people, I've heard a lot of stories where a lot of people took the vaccine that didn't want to on that topic. And the people who said, no, I'm not gonna, when it came right down to it, they didn't fire them because they were too essential to the business. So it's, this same kind of thing in effect. Like, if it's essential to the business and what you're going to do, you've got to make decisions that way, and then fight it if you need to.
Just feels like the system is constantly putting employers in the hot seat to pay attention to
Right.
where court cases are at and it's like we're just trying to do business here. You tell us when stuff is ready.
Right. Right. Well, and there's also the possibility too, if the FTC comes in and says, hey, this is it, the court could say, look, the non-compete is something that is sometimes essential for a business, but so many of them don't give enough consideration, meaning some kind of compensation for signing the non-compete. So if you don't have enough consideration on a non-compete, you usually lose those as well. So I could see where maybe there's some kind of hybrid that comes in and says there is some type of or base level of consideration that needs to be involved in a non-compete for it to hold up. Because you're essentially saying you can't go work or make money on this for a certain period of time.
Yep. All things to consider.
Yes.
Keeping us on our toes.
Yep. So what's this mean for your business? Again, we expect legal challenges on both. You can take a wait and see. You could say, hey, I'm going to keep my non-competes in place. I'm not going to do my minimum wage increases. I'm not going to do any of those things and see what happens. You could start assessing everything and then wait to see what happens so you're ready to go. Or you could make the changes, consult now and make the changes and evaluate the cost. If you have the idea of taking a wait and see, there are the risks of those things. If they become employees, employees know that these changes are coming. There is, between social media and all our mobile devices, the news is out there. Everybody knows it. You have to live under a rock to know that these things aren't happening. And so you really have to. You're not going to fool your employees into thinking that they don't have that issue. And if you aren't going to address it and at least have those conversations so that the employees know that you're looking at it, it's going to have a negative impact on your business. They're going to start looking to work with businesses that do other things. And then you're going to have where it disrupts your business. And the last thing you want is not be prepared. And then you end up in a situation where you're paying so many penalties and fines on things because they came after you that you're no longer competitive. So you really, really do have to be careful on how you look at it. At the least level of things is do all the analysis, be ready for it. If nothing happens, I'm going to tell you right now, eventually this will happen. These minimum wages on salaries specifically will go up, whether this stays in place or not. The non-compete, I think it's really one of those things that I would say you be prepared for your alternative method of what you're going to do, but and be ready for it. But I don't know if those will stay in place or not.
Yeah, I think what you mentioned too, like in social media, employees are aware. And I don't know if it's just my algorithm because I'm interested in human resources and all this stuff, but I think every 10 videos right now on my Instagram Reels or on my TikTok is, what do you need to know? How do you push back against non-competes? How to get out of your non-compete? So like you're absolutely right. Not only is it out there, but you hit it right on the nose, is that employees are getting educated. And I think what's hard is, they might be getting misinformation too. Like they might
Yes.
not be getting all the information. And so I think that's, going to be a challenge.
Yeah, 100%. They're getting misinformation. Everybody's got an opinion and they're going to hear all those things. So you really need to make sure that you're having an open dialogue with your employees. If in today's world, if you're not having an open dialogue with your employees about what your company's doing and how it functions and where you want to go and how you work with everybody, you're behind on it because, half the working population, they just want information and they want to know what's happening. Whether they act on it or not, they would rather have the information than not. And they know that you're looking at it this way, you're more competitive and they respect you more. And they want to make sure that you're actually paying attention to these things. And it builds trust with your people in your organization. So it's it is really important to communicate with them and make sure that you're addressing it. Because if you're not talking about it, I guarantee you they're talking about it amongst themselves. And they're all making plans about what they're going to do if you don't address it. Because that's just where it stands now. Oh, just real quick, so everybody has context. I'm not just some crazy car salesman that she got on here that doesn't know anything. Our business is this stuff, and we have three different businesses that we work with, and with our clients, we have comprehensive PEO services where we do everything across the board. If you're an employer but you don't want to actually have to worry about payroll and being the HR department and managing your benefits, we have a great relationship with Advanced Benefits on this. We don't sell the benefits; we manage them for our businesses and work directly with them. So it's a very
Symbiotic.
symbiotic. Thank you. Symbiotic relationship. It's great. And we do all that and provide that. Work directly with your employees to make sure they're taken care of, and do that. Beneficient is a company, again, it manages benefits and payroll. If you've got an HR department, but you need to make sure that you don't have the bandwidth to help your employees understand their benefits, and you want to make sure that all that's taken care of. We work with businesses in that regard. And then we have staffing services as well. If you need to flex your workforce, we bring those to you. So
You're not just some guy found on the side of the road.
exactly.
I can do a webinar about this. He's been in the biz, folks.
Yeah.
He knows what he's talking about. So, Stephen, I do have some questions. Thank you so much for that
Sure.
information. It's certainly given me a lot to think about when I'm working with my clients, because we do get asked these questions and it's hard because it's that I'm not a lawyer tee up.
Right.
I'm not a lawyer, but right. And that's kind of a hard conversation to navigate sometimes. I think you mentioned the salaried employee who's accustomed to kind of like logging in the evenings or just getting work done when they can. And we had that happen in our organization where we had an employee who moved to Washington State, much stricter rules from a state level about salaried employees, exempt employees. So, and sometimes it's part of a culture, right? Where
Right.
you're salaried, just get the work done, try to be available during work hours. But if you work in the evening, that's fine. And then if we see this shift where it's, employees are less likely to, be salaried, but it's part of a company culture. What do you see, or what would you recommend employers do to communicate that or to overcome that disruption?
Well, have the conversation again with the employees and help put a plan in place. If you're not big enough to have IT that can restrict those things, because you have the ability, at an enterprise level, like with Microsoft, for instance, and 365, is you can schedule when people get and send and receive emails from a global level. So you could let them have it on their phone, and let's say they do it all day long, but you say, hey, you know what? If you start doing email in the evening, and you're hourly, you have to be compensated for that. And then a lot of employees are hey, that's okay, I'll do it anyway. Well, things are always great when they're always great and everybody's getting along. When they're no longer getting along is when all those things come back to haunt you. And so that's why you need to make sure you've got the right policies and procedures in place. And whether you direct people. Now, you can tell people without even restricting, you say, look, you can put it on your phone so that you have it with you. when you're on the clock, if you're out seeing clients or doing whatever, but in the evening, you cannot respond to emails. You give them that as part of the policy of their job in their job description, it's enforceable. If they do it, you can say, hey, I told you not to do that, and I'm going to have to write you up and give you a warning, unfortunately, because you have to document those things in order to protect yourself. And so you can do that by policy and management. And then you just start creating the culture as well of, hey, this is how we have to work it. And it's unfortunate, and it's just the way of the world. Whether I agree with it or not is not going to come up right now, but
Yeah.
um,
Well, and
you just have to do that.
I think you're right too, and sometimes like, oh, you might have been in an organization where it's worked really well for you, but I think the reality of the situation is what you talked about, is that it's like we can all have nice things until somebody breaks it. And our
Right.
company didn't break it. This other company did, and they were exploiting their employees. So now we have to adjust our culture because of it, and I
Yes.
think maybe there's some room there to make someone else the bad guy,
Right.
especially when it's government.
Correct.
And then I know I'm putting you on the spot a little bit here, but given the number of clients you guys have and the employees that you interface with, have you had to start having these conversations, communicating to employees about these pending changes? And if you have you kind of started to hone in on what message is working the best, or is it still a little too early for that to tell?
Yeah, it's probably still early to tell whether there's one message. And I would always say there's one, there's always a data set of information that is going to be across the board. And how you message that is different depending on, the employee group, the industry they're in, and those things. And so we will always work directly with the client, because we have some clients that are like, yeah, send it out to everybody, we don't care. And there's other ones that are like, hey, we really want to be involved in that conversation about what you're building and what we're going to send out there. But that's what we get. One of the advantages that we have and our clients have is that we work directly with the employees. They call us when, with their HR department. So they're calling us the same way they'd call if it was an internal department. And we start to get a temperature of a client and what's going on with them by the calls we get from the employees, which we then give feedback to the management and the ownership of the company, so that they understand what it is, so we can work with them. But we're able to kind of help head things off a little bit as we start to get more questions from a client and say, hey, this stuff's going on in your organization that we should really help address. And we can then help message and get that out. And yes, we will get it all out to the employees, and we'll send that out for our clients. So it's not something that we just send them a template and then they are on their own to do. We actually will do it all for them and work directly with them. But I would say specifically on these, we'll start seeing more questions about the wage information, and we'll probably start seeing more questions about the contractor stuff.
Yeah, for sure. No doubt. Well, Stephen, thank you so much for your time today. This was a lot of really great information. And like I said at the beginning, I think it's really helpful to kind of cut through, if you read the news, if you're Googling stuff, you're getting a lot of opinion, and as you shared multiple times during this presentation, it's my opinion aside, right? Here's what it is. And so it's nice to kind of cut through all the bologna sandwich, if you will, and kind of get straight to the heart of the matter on where we're at with things. So I appreciate your time today. And
Absolutely. And I would tell, as you mentioned Google real quick, I would give everybody, be very careful Googling and living by information that you Google and get. Like the doctor says, don't ever Google your medical condition, because everything will kill you.
everything is cancer.
Exactly. There's a lot of misinformation out there, and we've seen a few things even with like Chat GPT and those, where they're pausing on what they'll actually give you, or they'll stop and say, this date, I have accurate information to this date, because there's so much misinformation out there that it can't figure what it is out. So they're starting to limit or tell you what they can and can't do. But be very, very careful. Find professionals that you trust, and talk with them, so that you can get information that you feel comfortable with and you trust.
Yeah. And at the end of the day, have a lawyer.
Yeah, definitely.
Have a lawyer.
Yep.
Awesome. Well, Stephen, thank you so much. I really appreciate your time today. Again, if you have any questions, you are more than welcome to reach out to us. We're happy to get you guys connected. We do work very closely with Stephen and his team over at AdderAccess and Province Management Group. They're fantastic. So if you have any questions about anything that you heard today or want to get connected to Stephen and his team, just reach out to us here at Advanced Benefits. We'd be happy to make an introduction or get those follow-up questions answered for you. And I just want to wish everyone a great afternoon. Thank you so much.
Thanks again, Arwen.
Thank you, Stephen. Have a good one.
You too.
Bye-bye.
Bye-bye.